Good afternoon and welcome to this month's WorkRite webinar. Today we're going to talk about some of the challenges that can be faced by new and expectant mothers in the workplace and the legislation that is in place to protect them. My name is Ryan Church, I'm the WorkRite Sales Manager here at Posturite, and with me again today is the all-round superstar Ellie Hale, who, as many of you will know, is our WorkRite Business Development Manager. During the webinar we've got a number of polling questions which I'll do my best to launch in the correct order and at the appropriate times. Your answers to these questions help us build a picture of your thoughts on various elements of the subject, and additionally, please do submit any specific questions you have throughout the webinar so that Ellie can have the opportunity to answer them at the end of the presentation. So Ellie, over to you.
Brilliant. Okay then guys, we're going to do things slightly differently this time. Normally I go through our e-learning courses and have a chat about kind of relevant topics around them. This time we're just going to give you some information. When I go to my WorkRite meetings, I get asked about pregnancy and pregnancy risk assessments and what we as WorkRite can do to help. So this time we thought in this webinar we'd just give some useful information about pregnancy in the workplace and some interesting facts about it, I think. So moving on. Just one sec, having a bit of a technical thing with my screens. There we go. In 2016, government-commissioned research revealed that 3/4 of pregnant women and new mothers experience discrimination at work. 1 in 9 lost their jobs as a result. With increasing numbers of women choosing to remain in work while pregnant or bringing up children, it is crucial that employers are fulfilling their duty of care to accommodate them in accordance with the law. In this webinar, we'll discuss the health and safety factors you must consider and how best to assess a new and expectant mother. So, working during pregnancy, the do's and don'ts of office life. So, working during pregnancy means preparing for all of those little things you know are going to happen during your workday, like hunger, thirst, nausea, or even headache. So bring several small snacks to eat throughout the day. Snacks help ease morning sickness, which can occur at any time of day. Stay hydrated. Proper hydration is key for pregnancy health, but dehydration can also make that morning sickness more pronounced, so drink often and take frequent breaks to walk around. Swelling, pain and fatigue are common during pregnancy and may become more of an issue if you sit at a desk all day. Take a 15-minute break every hour to walk around your desk a few times. Hike to the bathroom for a quick break and refill your water bottle. Walking may also reduce some of those aches and pains. So what are the main rights of pregnant employees? Paid time off for antenatal care, maternity leave, maternity pay and maternity allowance, and protection against unfair treatment, discrimination, or dismissal.
Perfect time there to launch our first poll. So here we go. Can we get it right first time? Possibly not. Here we are. Right, the question reads.
I'll just read a bit of backstory. So Sarah's always been very active. She's a keen kickboxer, but also enjoys a brisk walk in a nearby forest. Now that she is pregnant, she's afraid physical activity might harm the baby. So what should Sarah do? Should she keep active, but might want to avoid contact sports, and she should consult her GP before undertaking any exercise? Or should she engage in as much physical activity as possible? Contact sports are especially effective as they will exercise the unborn baby too. Or should she only engage in desk exercises, which her company must facilitate via an approved NHS consultant? Or should she get as much rest as possible and refrain from any unnecessary activity whilst pregnant? What do you reckon, guys?
I'm pretty sure it's about staying active. You know, the whole
Is that because contact sports will exercise the unborn baby?
It wasn't so much thinking contact
I'm
sports.
not a parent. You're experienced in this, Ryan. So.
Well, I got contact sports now the children are born, but in the pregnancy stage, not so much.
So has everyone had a go?
We've got everybody answered. So
and what have they gone for?
We've got the 93% said Sarah should keep active.
But will avoid the contact sports.
One, yeah.
Well done. Maintaining good levels of fitness can reduce sickness and improve post-birth recovery time. Contact sport or activity that increases the risk of heavy impact may be of risk to a developing baby, and it's recommended that you consult with your GP before undertaking any exercise. So antenatal care, one of the rights that that pregnant staff have isn't just medical appointments. It can include antenatal or parenting classes if they've been recommended by a doctor or a midwife. Employers can't change a pregnant employee's contract terms and conditions without agreement, because if they do, they are in breach of contract. Employers must give pregnant employees time off for antenatal care and pay their normal rate for this time off. The father or pregnant woman's partner has the right to unpaid time off to go to 2 antenatal appointments. So, pregnancy-related illnesses. Maternity leave and statutory maternity pay will start automatically if the employee is off work for a pregnancy-related illness in the 4 weeks before the baby is due. It doesn't matter what's been previously agreed. And compulsory maternity leave. If the employee isn't taking statutory maternity leave, they must take 2 weeks off after the baby is born, or 4 weeks if they work in a factory. And telling your employer about the pregnancy. Employees must tell their employer about the pregnancy at least 15 weeks before the beginning of the week the baby is due. If it's not possible, for example, if they don't know that they're pregnant, the employer must be told as soon as possible. Employees can't take time off for antenatal appointments until they've told the employer about the pregnancy. So, health and safety for pregnant employees. When the employee tells her employer she's pregnant, the employer should assess the risks to the woman and her baby. Risks could be caused by heavy lifting or carrying, standing or sitting for long periods without adequate breaks, exposure to toxic substances, and long working hours. Where there are risks, the employer should take reasonable steps to remove them, for example, by offering the employee different work or changing their hours. The employer should suspend the employee on full pay if they can't remove any risks, by offering suitable and alternative work. So you can see full details about all of this, which is where I've got the information from the Health and Safety Executive website. Pregnant employees who think they're at risk but their employer disagrees should talk to their health and safety or trade union representative. If your employer still refuses to do anything, then talk to your doctor or contact the Health and Safety Executive. So now we're going to go to another case study. Anna's?
Yes, we've got Anna's case studies ready.
So, Anna is 7 months pregnant. Her work colleagues know that she's pregnant because she's never made a secret of it, and it's now pretty obvious for anyone to see. Anna finds herself increasingly tired at work, but she doesn't have a suitable place to rest. Should her employer provide a suitable space? So, should they only if a workplace risk assessment has identified this as a requirement? Should it be only if the employer has a written notification? Does the employer not have to because it's not a legal requirement to provide a place to rest? Or is it yes, a place to rest must be provided as soon as the employer suspects an employee is pregnant? What do you reckon, guys? I wasn't sure about it. I mean, again, I don't have kids, so I've never had to do it.
My instinct.
You've never been pregnant.
Yeah. No, there's biologically not that capable.
Yet. It's going to happen.
But instinct says yes, but I didn't know if it was in when the written notification has been provided. But we've got most of the responses in so far.
I would have said it was just as soon as the not suspects. Yeah. Workplace risk assessment.
Okay. All in.
Yeah. What's everyone gone for?
For 44% yes,
15%
after the workplace risk assessment, and then split 16 and 11% across the no and the only if employers receive written notification.
So the answer is only if the employers receive written notification. The workplace regulations require employers to provide suitable rest facilities for workers that are pregnant, but until the employer receives written notification from the expectant mother, they're not required to take any action.
Interesting.
Yeah. So now we're going to talk about pregnancy and maternity discrimination. If an employer treats you unfairly because you're pregnant or because you've recently had a baby, you may have been discriminated against. The Equality Act 2010 calls this pregnancy and maternity discrimination. Discrimination is against the Equality Act and is unlawful. This means you can take action in the employment tribunal. You also have other rights under employment law if you're pregnant. For example, the right not to be unfairly dismissed. So, Pregnancy and maternity discrimination is when your employer treats you unfairly because you're pregnant or because you've recently had a baby, and you suffer a disadvantage as a result. For example, if you're dismissed or refused a promotion. The Equality Act says you've been treated unfavourably. And to show unfavourable treatment, you don't have to compare your situation to someone else's, for example, a man or someone who's not pregnant. All you need to show is that you were treated unfavourably. An employer mustn't discriminate against you because you're pregnant or because of a pregnancy-related illness. And after you've had your baby, it's unlawful to discriminate because you're on maternity leave, or you've been on maternity leave, or you've tried to take the maternity leave you're entitled to. So we're going to talk about specific case law. So mishandling requests for flexible working on return from maternity leave. This issue is most likely to cause a dispute between an employer and an employee returning from maternity leave. It's her hours of work. It's common for employers to receive requests to return from maternity leave on just a part-time basis, but there is no automatic right to switch to part-time working. However, an unjustified refusal to allow an employee to work part-time after having a baby is likely to constitute indirect sex discrimination. So in British Airways plc v Starmer, the EAT held that it was discriminatory for an employer to turn down a pilot's request on returning from maternity leave to work 50% of her full-time hours and required for her to work at least 75% of the full-time hours. That's quite a lot that they're entitled to.
A lot of time, yeah.
So health and safety legislation makes provision for risk assessments for pregnant employees and new mothers. Employers risk a finding of pregnancy and maternity discrimination if they do not abide by these rules. So they should carry out a pregnancy risk assessment. They should take action if a risk to a pregnant employee is identified. Carry out a new mother risk assessment and take action if a risk to a new mother is identified. The employer might have to alter the employee's working conditions or hours, or if any other action would not avoid the risk that's been identified. And if it's not reasonable to change her working conditions or hours, or this wouldn't avoid any risk, offer the employee a suitable alternative to work, or as a last resort, suspend the employee on full pay if there is no suitable alternative to work. Here we offer home working, don't we, for our head office staff?
A few options depending on the risk assessment, yeah.
Brill. So in Hardman versus Mullen, Orchard Lodge Nursing Home, the EAT held that the failure to carry out a risk assessment for a pregnant care assistant was sex discrimination, despite the employer's failure to provide a risk assessment in respect of any other employees. So that's quite interesting. I think you have to be super duper careful as an employer. Are we going on to Jane's case study now?
Yeah, we can do.
Super. So Jane is returning to work after her additional maternity leave. Jane's employer has hired a permanent replacement for her and therefore won't let her return to her old position. Jane is offered a similar job within the company but at a slightly lower wage. Can her employer legally do this? Is the employer not acting correctly because the new job's got poorer terms? Is the employer acting correctly because they're not obliged to offer Jane any job? Is the employer not acting correctly because Jane should be given her old job back? Or is the employer acting correctly because they've offered Jane a similar job? What do you reckon? They're all quite similar options there, aren't they?
They are very similar, aren't they?
God, it's difficult.
Personally, I think from what you've been saying with that case correctly is they have offered Jane a similar job, but I don't know.
But then is it discrimination because it's less money?
Potentially, I forgot you said less money as well. But
Please concentrate, Ryan. What does everybody reckon?
okay, we're almost there, so let's close the responses now. The answers are not correctly. The new job has poorer terms, 45%. Nobody answered correctly. They are not obliged to offer Jane any job. 43% not correctly. Jane should be given her old job back, and 11% said correctly. They have offered Jane a similar job. So 11% of people agree with me, but that doesn't mean to say it's correct.
Well, the correct answer is they're not acting correctly because the new job's got poorer terms. If employees take additional maternity leave, they've got the right to return to their job or a similar job. But similar job means the same or better terms and conditions. They can't go back to less than they were on before.
Okay.
Interesting. So, it can also be discrimination if inappropriate comments are made about pregnancy that amount to harassment. I can believe it when I read this one. A line manager's inappropriate comments to pregnant employee can lead to an employment tribunal claim. It may be that the line manager is annoyed at the inconvenience that he or she envisages will be caused by the employee's pregnancy and subsequent absence or maternity leave. However, employers should make it clear in line manager training that this is no excuse for making negative remarks to a pregnant employee at this important time in her life. In Wilson v. Provincial Care Services Agency and others, which is in Northern Ireland, the tribunal ordered that a care worker's former employer pay her £9,500 after it failed to provide her with a reference. And listen to these quotes. The tribunal accepted the care worker's evidence that the manager had said, "This is what happens when you have babies," when she resigned because she couldn't balance working hours with childcare, and that she was the big girl who wanted a baby and did not want to work when she tried to get a reference. I mean, that seems pretty black and white about what you should and shouldn't be doing there. Don't make those sort of comments. The big girl, dearie me. So failure to communicate with an employee on maternity leave. Employees on maternity leave should be consulted over a range of workplace matters, with problems commonly occurring if the employee is cut off from communication during maternity leave. For example, an employee on maternity leave should be consulted about any proposed redundancies or reorganisation so that she's got the same information as those at work. So don't forget about your pregnant staff or your staff on maternity leave. They should be given information about pay rises, bonuses and internal vacancies. To achieve this, line managers are allowed to make reasonable contact with employees who are on maternity leave, but obviously don't harass them. In Visa International versus Pool, the EAT held that an employee was constructively dismissed when her employer failed to notify her while she was on maternity leave of a newly created post in her department in which the employee was interested and considered herself well qualified for. It's quite a fine balancing act there. And failure to allow a woman to return to her old job after maternity leave. A common issue for an employee returning from maternity leave is finding that her job has changed beyond recognition. The employee could return to find that she's been given a lower level of responsibility or work that's not appropriate for her skills. Employers should remember that an employee returning to work after ordinary maternity leave, which is no more than 26 weeks leave, has the right to return to the job she occupied before her maternity leave. If the employee has taken additional maternity leave, i.e. more than 26 weeks leave, she's got the right to return to her job unless it's not reasonably practicable, in which case she's got the right to return to another suitable job on terms no less favourable. So I thought this case was really interesting. Blundell v. the governing body of St Andrew's Roman Catholic Primary School and another. The EAT held that a teacher was not entitled to return to the same class she'd been teaching when her maternity leave began. The school operated a policy of rotating teachers' classes every few years, and her job essentially remained the same. So, despite what the law says there about you must return to the same position on the same terms, because of the school's common practice and the way that they generally ran their schooling, teachers changed all the time, so it wasn't reasonable for her to expect to go back. I thought that's interesting. So you can't also base recruitment decisions on an employee's family situation. So no line manager training on recruitment is complete without a stark warning of the dangers of asking a job applicant in an interview about family plans. For example, line managers should be warned not to ask job applicants with children about their children or childcare arrangements, or women who are pregnant about their plans for maternity leave and childcare. Interviewers should stick to exploring the job applicant's ability to perform the job. It is blatant pregnancy and maternity discrimination to base recruitment decision on an employee's pregnancy or family plans. In Webb versus EMO Air Cargo, the ECJ made it clear that it is discriminatory to dismiss a woman who, shortly after her recruitment, is found to be pregnant. And that's the end of the slideshow there. We've got one more case study, which is Christine. So Christine works on the 5th floor of a busy office. As she is heavily pregnant, she has agreed with her manager that she doesn't need to take part in fire exercises, and in the case of real fire, she will be permitted to use the lift. Is this an appropriate arrangement? Is it, as long as Christine and her manager are in agreement, then no further risk assessment or arrangements are required. Should Christine immediately be suspended from work because she presents a fire hazard? If Christine can't follow the normal fire safety procedures, then she may make her own arrangements but at her own risk. Or does it just not sound like an appropriate personal emergency evacuation plan?
This is a trickier one.
Is she just a fire hazard? If her and her manager are in agreement, they don't need a further risk assessment. Should she make her own arrangements, or does it just not sound appropriate at all?
We've got quite a strong sort of decision direction with everybody here. Everybody's in, and close that. There we go. 95% says it's not appropriate.
It's not appropriate. The employer is obligated to consider fire and safety arrangements for Christine. This usually takes the form of a personal emergency evacuation plan. It's vital that competent advice is sought before implementing any controls. So the case studies, the little questions that we've offered you, are part of our new and expectant mothers awareness package that we have. Lots of our existing WorkRite clients add it on as part of their kind of assess right assessment. We've got a special for everybody. All our existing WorkRite clients that have registered today and tuned in, you can get that for £500 as long as you register your interest with us today, and we can get that added on within the next week. So if you want to have a trial, please let us know, get in touch, and we can organise a demo of our new and expectant mothers awareness course. It's great for managing difficult conversations. We advise that not just the pregnant staff member does it, but maybe line managers, sometimes teammates as well, just to make sure everyone's on the same page. It's quite effective there.
Excellent, Ellie. Well, I think that sort of brings us to a natural close. Next month's webinar, we will be publicising the date and the subject in the next week or so. So if you've got any particular requests on subjects that you'd like us to cover, please drop us a query, speak to your account manager, come in to us directly. But yeah, once again, Ellie, thank you very much, and thank you for joining us today.
Thanks, Ryan.